Within this presentation, we'll explore the legalities of the employer-employee relationship as applied to fire departments and EMS agencies. Once completed with this module, you should be able to discuss and explain the following: the doctrine of respondent superior, the impact of negligent hiring, training, supervision, and retention, the legalities involved in providing employment references, the legal relationship between labor unions and employers, the legal aspects of having dress codes and grooming standards, the legal aspects of providing religious accommodations to employees, the legality of residency requirements, employee privacy rights while on the employer's property, the role of candidate testing in both initial hiring and promotion, the legal aspects of employee drug testing, the legal aspects of employee genetics within the employment relationship, and the legal aspects of using polygraphs during interviews and investigations of employees. To begin our discussions about the legalities involved in the employee-employer relationship, imagine for a moment that you are a fire chief and just found out that one of your personnel was involved in a serious motor vehicle accident involving a departmental vehicle while running a personal, not work-related errand late at night. To begin, what is the fire department's responsibility for or liability because of the accident? If the city or the fire department is sued by those injured in the other vehicle, is there any mechanism by which the city or department can avoid liability? You also learn that the fire department officer submitted to a breathalyzer and a blood draw at a local hospital emergency room for routine drug screening in accordance with routine procedures. Can the results of those tests be used in a disciplinary process against the fire department member if he was under the influence in violation of the city's policy? Lastly, a local media outlet made an open records request for the fire department officer's medical records. Should that request be granted? What privacy rights does the public employee have in his or her own employment medical records? The answers to these questions, and many others related to the employment relationship, will be covered within this presentation. To begin, much of what we will be talking about in this chapter relates to both private sector and public sector employees. To clarify, a public sector employee is one who works for a governmental entity, whereas a private sector employee works for a non-governmental employer, such as a private ambulance company. In some factual scenarios, however, how the law applies may vary depending on whether the employer is a governmental entity or a private one. As we discuss the laws that apply to the employment relationship further within this chapter, if the differentiation between public sector and private sector employment is an important one, I will be sure to mention it. As far as the employment relationship is concerned, let's begin by discussing the doctrine of respondent superior, which is Latin for let the master answer. Under the doctrine of respondent superior, if a servant, an employee, is performing work under the direction of his or her master, the employer, the master is vicariously liable for the servant's actions if a civil harm results. The employer is considered to be the principal in this employment relationship, with the employee being the employer's agent. So long as the agent is functioning within the scope of his or her employment for the principal is typically held liable for the negligent or harmful actions of the agent. Within emergency services, this means that a fire department or an EMS agency may bear liability for the harmful or wrongful actions of its firefighters or EMS providers. The key is whether or not the agent is functioning within the scope of employment. If the agent is not functioning within the scope of his or her employment when a civil harm occurs, that agent is said to be on a frolic, and the principal may be able to sever itself from liability to the harmed third party. Thinking back to the example at the start of this module, the on-duty fire officer who was running a personal errand in violation of policy was arguably not performing work within the scope of his employment, which may allow the fire department to seek withdrawal from the resulting lawsuit. If such personal errands were allowed by the department, however, then the officer would have arguably been functioning within the scope of his employment, and the fire department would still be responsible for his presumably negligent conduct that precipitated the motor vehicle collision. For further examples of how this doctrine works, the textbook contains a couple cases that provide some additional clarification. Over time, several negligence torts have emerged related to the hiring, training, supervision, and retention of employees. If an employer makes a poor employment decision, fails to provide adequate training, fails to adequately supervise, or fails to discipline as appropriate, and someone else is harmed as a result of those negligent employment acts, there is the potential for a lawsuit to be filed given the negligent hiring, training, supervision, or retention of the problem employee. As an example, hiring a non-certified firefighter or failing to provide training to a paramedic on a new 12 lead could give rise to employer civil liability if a third party is harmed as a result of that poor hiring decision or failure to train. Digging deeper, negligent hiring often arises when an employer hires someone without screening for the use of illegal drugs, it fails to perform adequate criminal background checks, or the employee cannot perform essential job functions even with accommodations. If these shortcomings in the hiring process prove to be the proximate cause of some type of harm to another person, the employer may face a negligent hiring lawsuit. Now, while it is true that it is illegal to discriminate based upon disability, and some states make it illegal to discriminate based upon criminal background, unless that background is substantially related to the job, that still does not mean that the employer cannot maintain minimum qualifications or standards of its new hires. Due diligence in emergency services employee hiring is critical to ensure a qualified workforce that can effectively mitigate emergencies. Once you have an employee working for you, it is necessary to ensure he or she is adequately and appropriately supervised. When an employer fails to reasonably monitor or control the actions of an employee and that negligence is responsible for damages to another person, negligent supervision may have occurred. Negligent training may be alleged if an employee injures someone because he or she did not receive the training necessary to function safely in the position, or the employer failed to remediate a pattern of employee behavior that could foreseeably give rise to an injury if not corrected. Those in leadership and management positions recognize the need to occasionally coach, mentor, develop, and possibly correct employees when performance becomes an issue. If it is clear that an employee is misusing the authority imbued in his or her position in a way that poses a danger to others, that employee should be removed from the position immediately. If that same employee is not removed from a position where he or she interfaces with the public and a harm occurs to a member of the public as a result of that known problem, a negligent retention claim may potentially be substantiated against the employer. As we just talked about coaching and training for employees, another subject that goes hand in hand with developing employees is that of conducting performance evaluations. Employers commonly use performance evaluations to review employee performance on a periodic basis while providing opportunities for coaching, mentoring, and personal development. To limit potential legal problems, all such performance evaluation processes should be consistent and fair. Performance should be documented honestly, and all feedback should be objective, not subjective. Using a performance evaluation system for retaliatory purposes is a problem that may create significant legal liability for an employer, as such circumstances are typically apparent given the evidence available in conjunction with a timeline pertinent to the retaliatory conduct. Legal concerns aside, performance evaluations should be used as a positive mechanism to increase employee satisfaction and performance. Along those lines, your performance evaluations should be meaningful and not just something that is pulled off the proverbial shelf once a year to satisfy some policy or procedure. Again, such systems must be properly designed and implemented. It is important to document both positive and negative feedback, as doing so provides credibility for the system and, hopefully, helps recognize employees who consistently meet goals, provide good customer service, and perform their jobs well. In the unfortunate event that an employee requires discipline or even termination, these evaluations will be important in deciding whether or not the actions taken by the employer were reasonable under the circumstances. This is where private versus public employment can be important, as a public employee who is not on probation has a constitutionally protected property interest in his or her job, and due process is required to fire that employee. If the employee's performance evaluations are all positive up to the point of a possible termination, the event that necessitated the termination must be significant to forego the progressive discipline process. A private sector employee, on the other hand, is typically considered to be an at-will employee and can be terminated for virtually any reason, so long as that reason is not illegal, such as illegal discrimination, for example. If you are a manager within a fire department or EMS agency, it is not unusual to field phone calls from other employers seeking information on your previous employees who are now applying for positions with them. As the laws on this subject can vary from state to state, it is recommended that you draft a reference policy with the advice of an attorney familiar with such matters. With that being said, it is typical for state laws on the subject, if they exist, to recognize the ability of employers to provide employment references so long as they are provided in good faith. This means that there must be no ill will, unethical motives, or other inappropriate comments that cannot be substantiated by evidence and data. Employment references given in bad faith can create liability on several fronts for the employer. If you give a bad faith reference for an employee who did not deserve it, that employee or former employee may be able to sue for defamation. On the flip side, if you give a positive reference in the hopes of seeing a bad employee leave the organization and go somewhere else, that could be considered a misrepresentation or negligent reference by the agency seeking the reference if they hire the person upon your recommendation and it turns out that the employee is nothing but trouble. When an employer is asked to provide an employment reference, there is typically no legal requirement for him or her to do so. If the employer decides to provide a reference, however, it is imperative that such references, positive or negative, be provided in good faith. Given the nature of firefighting and EMS work, it is important for the public to have certain assurances that its firefighters and EMS providers are of the highest integrity. For this reason, it is not uncommon for employment offers to be made contingent upon successfully passing a criminal background check. There are private companies that can assist with these services. Some states have an online process by which anyone can run a criminal background check on another person, and some fire or EMS agencies rely on their local law enforcement to conduct background checks. The laws governing the use of such checks vary quite a bit from state to state. Some states actually prohibit discrimination in employment based upon a candidate's criminal background unless the infraction on the criminal background is substantially related to the profession. Some may require the prospective employees' consent to run a background. Beyond criminal backgrounds, some employers run financial backgrounds as well. Whether such a background check is legal can depend on the laws of the state. As already mentioned numerous times over, fire departments and EMS agencies should work with their local attorney with expertise in this area to ensure they are following the laws related to this subject within their particular state. We are now going to spend some time talking about organized labor, unions, and its relationship with management. Needless to say, organized labor has had a significant impact on the fire service within the United States. While there is federal legislation that applies to organized labor, states typically have laws and other provisions in place that further define the employee-employer relationship in unionized environments. To understand organized labor today, it can be helpful to know how it developed. The labor movement in the United States began in the late 1700s to combat poor working conditions in industry. The first organized strike was actually recorded in 1768. Unions commonly began as local, isolated entities that often grew to the point where many were consolidated into larger nationwide bodies. One such nationwide union is the American Federation of Labor, which was formed in 1886 to represent workers in specific trades. A few decades later, in 1935, the Committee for Industrial Organization was formed. About 20 years after that, the two joined to create the AFL-CIO. Today, most labor unions exist under the umbrella of the AFL-CIO, including the International Association of Firefighters. At the time this presentation was created, the IAFF claimed to represent more than 300,000 full-time firefighters and paramedics across more than 3,200 locals in the United States and Canada. Regardless of how one may feel about organized labor and unions, there is no denying the significant impact the IAFF has had on the legislative process at both the state and federal levels. While many states have been working recently to reduce the collective bargaining power of organized labor, the impact of unions on today's work environment is still evident, especially in the area of governmental employment. While it was passed quite some time ago, the development of organized labor unions within the United States was fostered by the National Labor Relations Act. This law, passed in 1935, was designed to protect the rights of employees and employers, to encourage collective bargaining, and to curtail certain private sector labor and management practices that can harm the general welfare of workers, businesses, and the United States economy. Under the NLRA, employees are guaranteed the right to organize a union to negotiate with an employer, to collaborate with co-workers to improve working conditions, and to strike or picket if so warranted. It also made some union activities illegal, such as threatening employees if they did not support the union or discriminating in job referrals. Some employer actions were also deemed illegal, such as discouraging or threatening employees based upon union involvement, threatening to close the workplace if workers joined a union, and so on. A more comprehensive list of guaranteed rights and prohibited actions under the NLRA is included within the textbook. An arguable deficiency of the NLRA, depending on your perspective, is that it applies only to most private sector employers and employees. It does not cover the public sector. Some additional categories of workers are also not covered, such as agricultural and domestic workers, independent contractors, employees of air and rail carriers, and supervisors. With that in mind, the ability for public employees to unionize is commonly defined by individual state law provisions. The National Labor Relations Board is responsible for enforcing the NLRA. If there is an allegation of wrongful conduct under the law, the NLRB Regional Director investigates the complaint and can negotiate a settlement, refuse to issue a complaint, or refer the case to an administrative law judge for a hearing and decision. If it goes to that step, the administrative law judge may dismiss the case, issue a remedial order, or consider additional actions as proposed by the NLRB. In addition to resolving disputes under the NLRA, the NLRB is also involved in the process of both forming and decertifying labor unions. This slide includes a copy of the flowchart used by the NLRB to handle an unfair labor practice complaint. There is a copy within the textbook as well, which may be easier to read. Again, the NLRA does not apply to public sector employees. It is up to the states to decide how they want to handle organized labor within their respective borders. Therefore, if public employees are unionized, it is state law that governs that particular labor management relationship. With that in mind, some states not only recognize the right of employees to unionize, but they also provide statutory protections for unions that actually improve their effectiveness or viability within that state. Depending on the laws of the state, the union security provisions we are about to discuss may also be included within the language of a collective bargaining agreement between the union and the employer. One of the most common union security provisions is a dues checkoff. Unions need money to support their activities, and those funds are typically generated from the union's own membership through regular dues. These funds are then used by the union to support important initiatives and activities. A dues checkoff provision allows the union to collect its dues directly from the members through an automatic payroll deduction managed by the employer and subsequently routed to the union. Fair share provisions recognize that some employees may not necessarily be a part of the union, yet, because they fall under the provisions of a collective bargaining agreement negotiated by the union, they are still required to pay their fair share of dues to the union. There was a Supreme Court case in 2014 that came out and softened the fair share requirements for partial public employees by stating they could not be forced to pay their fair share for union collective bargaining activities if they are not a part of the union. This case was very specific in its application to home care workers who provided public services while under the employ of a private entity. Fair share provisions are still very powerful within the realm of standalone private sector and public sector unions. Unions typically feel very strong about the right to require non-union members to pay their fair share, as the unions are required to represent those individuals through the processes defined within the collective bargaining agreement, even if they are not dues-paying union members. Those services come at a cost, and fair share provisions help to ensure the financial ability of the union to represent all employees who fall under the terms of a collective bargaining agreement, not just union members. Some collective bargaining agreements require that employees become union members within a certain period of time after being hired. This is known as a union shop provision. States that claim to be right-to-work states commonly make union shop provisions illegal. An agency shop provision requires employees to pay union dues even if they are not members of the union. The difference between a union shop and an agency shop is that union membership is not mandated as a condition of continued employment within the agency shop. Preferential shop provisions require the employer to give preference in hiring, layoffs, dismissals, promotions, and work shifts to union members first. Given such a provision, if the union is unable to supply adequate qualified workers, the employer may hire non-union workers to fill the gaps. Some books and resources also discuss open shop provisions, which are not really a security provision for the union, as open shop means the employees are not required to join the labor union to work. The last union security provision to mention is a maintenance of membership provision. Given such a provision, there is no requirement that the employees join the union, but if they do, they must remain members for the duration of their employment at that workplace. As mentioned briefly before, some states call themselves right-to-work states, which means they have laws that prohibit most or all of the union protections we just defined. In these states, employees have the right to work without having to join a union, pay dues, or pay their fair share. These state law provisions commonly apply to both public and private sector employers and employees. Aside from the obvious impacts to organized labor given the loss of the union protections we just discussed, if the union still represents employees in collective bargaining, it must still represent all of those employees covered by the contract, even if they are not members, do not pay dues, and do not pay their fair share. This obviously has an impact on the ability of the union to function adequately if enough people are not paying dues or their fair share. For those workplaces with an active union, there can be occasional debate as to which employees should be in the union or, in workplaces with multiple unions, to which union a particular employee should belong. As an example, fire chiefs are clearly considered management and, depending on the laws of the state, are typically excluded from participating in a union. On the other hand, some battalion or deputy chiefs do belong to a union in some states. Mid-level managers, such as duty lieutenants, are sometimes in the same union as those they supervise. When such questions arise, the application of state laws that typically look to the community of interest served by the particular union are used to determine whether a particular employee or group of employees can unionize and, if so, into which union they should belong if multiple unions exist. While unions serve many functions within the employee-employer relationship, one of their primary functions is to bargain collectively on behalf of its membership with the employer for items related to wages, hours, and working conditions. This role provides some significant benefits for both the employees as well as the employer, believe it or not. From the employee side, the union can attempt to leverage the strength of the entire represented workforce when negotiating with the employer. On the flip side, the employer needs to bargain only with the union instead of each individual employee. Because a single agreement governs the wages, hours, and working conditions for an entire group of employees, the collective bargaining agreement can actually make things easier on managers within the organization by outlining contractual provisions that apply to all employees within the bargaining group. The collective bargaining agreement also gives the employer a certain level of plausible deniability if the employees are unhappy with the agreement because it was their own union that bargained for the provisions within the agreement. Another benefit that routinely arises from the terms of a collective bargaining agreement is that employees are treated the same given their status as defined within the agreement. This means that gender, race, disability, and other applicable classifications that routinely serve as the basis for illegal discrimination are not considerations in work actions taken under the terms of a collective bargaining agreement. This helps to ensure fair treatment and equity across all employees within the bargaining unit. One of the complaints commonly levied at collective bargaining agreements is that they tend to stifle creativity and effort, as employee wages are typically capped given the terms of the collective bargaining agreement, and things like merit pay or salary increases based upon productivity, innovation, or exceptional performance are not routinely included within such agreements. Some have also argued that collective bargaining agreements tend to cater to the lowest common denominator, protecting those who are poor performers without rewarding those who go over and above the call of duty. While opinions vary as to whether or not collective bargaining is a good or a bad thing, the process of collective bargaining does indeed have some very positive aspects associated with it that should be considered in such discussions. As far as collective bargaining is concerned, state laws commonly recognize 3 different topics that relate to the process of collective bargaining. The first topic includes mandatory subjects of collective bargaining. These mandatory subjects include wages, hours, and working conditions. By saying the subjects are mandatory, that means they must be discussed by the parties to the collective bargaining process if they want to be discussed by one of the parties. It also means that management cannot unilaterally change any of these provisions without first addressing them through the collective bargaining process. On the other end of the spectrum are prohibited subjects of collective bargaining. These are topics that cannot be part of a collective bargaining negotiation even if the parties want them to be. A very common example is that most states make it illegal for protective service employees to strike. As a result, it is not possible to bargain language into the collective bargaining agreement guaranteeing the workforce the right to strike, as that particular subject is illegal by state law and, therefore, a prohibited subject of collective bargaining. In the middle, between mandatory and prohibited subjects of collective bargaining, are permissive subjects of collective bargaining. These subjects are topics that do not fall into either the mandatory or prohibited categories. Permissive means just that. They can be discussed and bargained, but neither party is required to entertain them if it does not want to. While we will talk about collective bargaining impasse in just a little bit, if an impasse does occur, permissive subjects of collective bargaining cannot be included in the dispute resolution process. Additionally, just because a subject is permissive and not mandatory does not necessarily mean an employer can just unilaterally implement changes related to that topic without first bargaining with the union about it. Along those lines, while parties do not necessarily have to bargain over permissive subjects of collective bargaining, any efforts they make in bargaining must be in good faith. Stated another way, while the collective bargaining process involves give and take on the part of both parties, union and management, there is no requirement that one party give up on something in which it firmly believes or wants to see included or excluded from the agreement. The threshold for good faith bargaining is that the parties participate actively in the deliberations so as to indicate a present intention to find a basis for agreement. This implies both an open mind and a sincere desire to reach an agreement and find common ground. Bargaining in bad faith would include refusing to meet and negotiate, continuously canceling bargaining meetings with the other party, or otherwise acting in such a fashion that indicates a lack of good faith. Such bad faith tactics could be employed by either side, which stalls the process and ultimately reflects poorly on the party functioning in bad faith. As just mentioned, however, bargaining in good faith does not mean the parties to the collective bargaining table have to give up on important matters. Even when both sides of the table are bargaining in good faith, it is possible that they are unable to reach an agreement. When that occurs, an impasse is declared. Under the NLRB, an employer may declare an impasse when it feels it is clear that no further progress can be made on reaching an agreement and implement its last offer presented to the union. The union can then follow up by filing an unfair labor practice charge against the employer with the NLRB. Depending on the circumstances, the NLRB may require the employer to re-enter the bargaining process. At that point, both sides may also resort to other mechanisms to force the hand of the other party, so to speak, such as a strike or an employer lockout. Generally speaking, such actions are routinely prohibited in the protective service professions, but there are times when such tactics are employed in other professions. Individual states may also provide options for both sides to declare an impasse, and alternative dispute resolution mechanisms such as mediation and arbitration may be an option for resolving the impasse. If mediation or arbitration are allowed or mandated by state law to solve an impasse, the process can be helpful or detrimental to the respective parties depending on the particular facts of the impasse and how the laws address those processes. To begin, mediation is a process by which an independent third party, external to the collective bargaining agreement, is brought in to assist the parties with the negotiation process. While the mediator has no authority to force a settlement, his or her job is to guide and mediate the discussions through facilitation and persuasion to develop consensus and an agreement between the parties. If the parties are at an impasse because they cannot agree, one may wonder what good a mediator would do in such a situation. If the mediator is skilled and effective, however, mediation can be an effective tool for helping the parties move past their impasse to reach an agreement. If mediation fails or is not an option, arbitration is yet another form of alternative dispute resolution that is commonly employed to solve an impasse. There are different types of arbitration used by different states. Some arbitration processes are voluntary, some are binding, some are non-binding. There's final offer arbitration. Some use a single arbitrator, others use a panel of arbitrators, and there are other iterations out there as well. Ultimately, the purpose of arbitration is to force, not mediate, a settlement. Sometimes the threat of arbitration is enough to force a settlement because binding arbitration could be risky for the parties as no one knows ahead of time how an arbitrator will rule in a particular case. While judicial review is available for arbitrator awards, so long as the arbitrator was not arbitrary or capricious in producing an arguably erroneous or unconscionable decision, the court will defer to the arbitrator's award. Another dispute-related issue that arises routinely under a collective bargaining agreement are grievances. A grievance occurs when one party to the collective bargaining agreement, typically the union, alleges that the other party, management, has violated the agreement in some way. This is yet another area in which collective bargaining is a benefit to management because the union owns the grievance under a collective bargaining agreement. This means that individual workers cannot bring their own grievance under the collective bargaining agreement. Rather, that worker must raise the issue with the union, which then decides whether or not to pursue the issue. So long as the union acts in good faith and fair representation to the members, it may actually decide to not pursue an individual member's grievance. On the other hand, the union can decide to pursue a grievance on behalf of the membership, even if the impacted member does not want a grievance filed. Again, the union owns the grievance. Collective bargaining agreements typically define a grievance process whereby the first steps are usually handled internally to the organization. If the matter cannot be resolved between the parties in these early stages, however, alternative dispute resolution, such as mediation or arbitration, may be required. As with impasse arbitration, grievance arbitration has inherent risks, so it is typically in the best interests of the parties to attempt to resolve the dispute between themselves. If the issue does go before an arbitrator, however, the decision is usually upheld by the courts because arbitration language in a contract was a bargain for exchange between the parties, and the courts are hesitant to substitute their own interpretations of the contract language for that of the arbitrator, who arguably has special knowledge about the workplace that the court does not have. As far as collective bargaining agreements are concerned, there is no one model followed by all agencies and unions. Rather, collective bargaining agreements are unique and address the specific needs and issues that apply to the respective organization and its organized workforce. Some collective bargaining agreements are very comprehensive and detailed. Others are not quite so. Regardless of how well or poorly a collective bargaining agreement is drafted, there always seem to be subjects that come up that may not have been addressed by the agreement itself. If there exists a routine work or employment practice that is not defined, outlined, or included in the collective bargaining agreement, that work or practice is commonly considered to be a past practice within the workplace. These past practices form the basis for a reasonable expectation on the part of the employer or employee that the practice will be continued in a similar circumstance. Therefore, if a past practice is violated, it may give rise to a legitimate grievance. The more deeply rooted a past practice is in a work environment, the more likely an arbitrator will consider that past practice to simply be a part of the collective bargaining agreement, even if it is not specifically delineated as such within the agreement. There may even be instances in which a past practice conflicts with language contained within the collective bargaining agreement. If that happens, an arbitrator will typically defer to the clear language within the collective bargaining agreement unless it can be shown that the past practice has preempted that language over time. If a union is relying upon a past practice as grounds for a grievance, it may be on somewhat tenuous grounds, as an arbitrator may ultimately need to determine just whether or not that practice is indeed deeply entrenched within the organization and the labor management relationship. If a topic is important, it should arguably be included within the collective bargaining agreement, even if a past practice exists. Keep in mind that a collective bargaining agreement is indeed a contract and, as such, is typically defined by its own terms to be effective for a specific period of time. While 2 to 3 years may be a typical lifespan of a collective bargaining agreement, longer or shorter terms are possible. At some point, however, the agreement will expire, and it is then incumbent upon the parties to renegotiate terms within the existing contract or, less likely, simply create a new one. Given that the collective bargaining process can be complicated and cumbersome, there are instances where the contract expires before a new agreement can be formalized. When this happens, the terms of the expired contract continue to be applied to the labor management relationship until a new collective bargaining agreement can be formalized. As mentioned previously, the union is the sole representative of the employees it represents, and it is responsible for both collective bargaining with the employer on behalf of its members, as well as dealing with grievances as they arise. Individual employees covered by the collective bargaining agreement cannot bargain with the employer on their own behalf, nor can they file their own grievances if they feel a term of the agreement has been violated. For this reason, the union is recognized to owe a duty of fair representation to everyone covered under the terms of the collective bargaining agreement, which includes dues-paying members, fair share non-members, and even those who are non-members that do not pay their fair share in right-to-work states. We already mentioned that a union need not process every grievance it receives, which is typically when the question of fair representation arises. So long as the decision to not pursue a grievance is not arbitrary, capricious, discriminatory, or otherwise made in bad faith, the upset union member, or non-union member for that matter, will have a difficult time proving the union failed in its duty to fairly represent him or her. Union members are also recognized by the courts to have certain rights. The first such right is known as Weingarten rights. Employees have the right to engage in concerted action for mutual aid and protection, and denying a union employee representation by the union during a disciplinary meeting or hearing violates that right. For Weingarten rights to apply, the meeting between the employee and the employer must be investigatory in nature. Non-disciplinary meetings for coaching, performance reviews, or other related activities are not covered under Weingarten, which means the employee does not have a right to union representation at those types of non-disciplinary meetings. If an employer violates an employee's Weingarten rights, the employer has engaged in an unfair labor practice, and information obtained during the meeting cannot be used against the employee in disciplinary proceedings. While the Weingarten case involved a private sector employer covered under the NLRA, these rights are broadly recognized as applying to public sector employees as well. Generally speaking, there is no requirement that an employer notify an employee of his or her Weingarten rights. Some states, however, may impose that burden on employers or may provide additional worker protections beyond those identified by the Weingarten Court. Garrity rights are another court-created protection that applies to employees given certain circumstances. Under Garrity, the court recognized that employers have the right to ask their employees job-related questions, especially as they relate to potential wrongdoing and subsequent discipline. If an employee fails or refuses to answer these questions, especially within protective service employment, the employer typically considers the employee to be insubordinate, which can be grounds for termination. If the case in question involves potential criminal conduct, however, the Fifth Amendment of the Constitution secures the right to not have to provide witness against oneself. The accused may refuse to answer out of concerns for potential self-incrimination. Before Garrity, public sector employees could find themselves in the precarious position where they can refuse to answer questions and, thus, be fired for insubordination, or they go ahead and answer, thus providing information that may be used against them in a criminal case. The Garrity Court resolved this issue by requiring public sector governmental employers to make a choice. The employer may compel the employee to answer the questions and then forego the use of any evidence obtained in a subsequent criminal proceeding, or the employee may choose to not answer and the employer has to seek other means to investigate the incident without holding the refusal to answer against the employee. There is some lingering confusion as to when Garrity actually applies given different factual circumstances, and there is also a question as to whether Garrity applies automatically in those circumstances or if the employee must specifically invoke his or her Garrity rights. If you remember in a previous presentation that some states have laws commonly referred to as a firefighter Bill of Rights, if such laws exist within your state, firefighters may have additional procedural protections in a disciplinary process beyond both Weingarten and Garrity rights. As always, it is incumbent upon you to be familiar with the laws that apply in your state given related circumstances. We already touched briefly upon unfair labor practices, but we'll delve a little further into the topic here. Unfair labor practices, also referred to as prohibited work practices, are actions considered illegal under the NLRA and similar labor relations laws as defined by individual states. These unfair labor practices apply to both the employer as well as the union and include the items listed on this slide, which is a reproduction of Table 10-1 from the textbook. Associated with unfair labor practices is the union security provision known as a closed shop provision. Such a provision required employers to hire only union members, and all employees had to retain their union membership at all times to stay employed. Under the Taft-Hartley Act of 1947, closed-shop provisions were made illegal. Another interesting wrinkle related to paying union dues is that union members still retain their First Amendment rights to free speech, free association, free practice of religion, and personal expression. As an extension of these rights, unions cannot force their members or fair share paying non-members to pay for political action activities. Essentially, unions can force the payment of member dues and fair share dues for collective bargaining and grievance representation activities only. If a member or fair share paying non-member objects to a particular political action activity of the union must figure out what share of dues goes to support those activities and must remove that amount from the dues paid by that member or fair share non-member. As we also mentioned previously, employers can lock out employees when contract negotiations reach an impasse, and those private sector employees also have the ability to walk off the job in the form of a strike or to organize a work slowdown. Given the unique and vital nature of certain public services like law enforcement, fire protection, and emergency medical services, however, it is not uncommon for states to have laws in place that prohibit such practices for public safety employers and employees. Earlier in this module, it was mentioned that there are sometimes differences in the employment relationship based upon whether the employer is a governmental entity or a private entity. The termination of the employment relationship by the employer is indeed one of those areas where there is a significant difference between public and private employment. In brief, individuals working for a governmental entity typically enjoy more rights or security in employment than those working in private industry. The reason is that when the government is functioning as an employer, it must still comply with constitutional provisions that do not directly apply to private, non-governmental employers. These include Fifth and 14th Amendment due process rights. Before the government can deprive someone of life, liberty, or property, that impacted individual must be provided with procedural due process. So how does that apply to the employment relationship? If a public employee has a reasonable expectation of continued employment with a governmental employer, that employee has a constitutionally recognized property interest in his or her job. To be clear, it is not the Constitution that creates a property interest in a governmental employee's job. Rather, that property interest is created by existing rules or understandings derived from various sources, such as collective bargaining agreements, state law, and past employment practices. Once that property interest is vested, the Constitution then steps in to protect that individual's property interest. This means that a public employee with a reasonable expectation of continued employment cannot be terminated for reasons that are arbitrary, capricious, in bad faith, or on a whim. The employer must show just cause for the termination, which means the employer must show an honest cause or reason for the termination, regulated by good faith on the part of the employer. In such cases, the employer must afford the employee due process before the termination can occur. This is why certain workplace practices, such as progressive discipline or clear policies and procedures on workplace expectations, are so important, as they help establish or show due process in the disciplinary and termination processes. Whether or not the public employee has a reasonable expectation to continued employment is key to determining whether or not a property interest exists. Even in public employment, there are circumstances where the reasonable expectation of continued employment does not exist. The first such case is if the employee is specifically hired as an at-will employee. At-will employees are hired with the expectation that either party may terminate the employment relationship at any time for almost any reason, so long as that reason is not illegal, such as illegal discrimination in violation of the Civil Rights Act or the ADA, for example. The employee may be terminated from the governmental position without regard to his or her due process rights. Such at-will employment is not unusual for public service managers, such as a fire chief or an EMS service manager. If an individual is considered to be a probationary employee during a period of time after his or her initial hire, that employee also lacks a property interest in the employment. This probationary status is important because the probationary employee does not have a reasonable expectation of continued employment. This gives the employer the opportunity to determine if the new hire is actually a good fit for the organization. So long as the employer does not make the termination for an illegal reason, the probationary employee can be terminated without regard to potential due process issues that would exist if he or she was not a probationary employee. If necessary, many states also allow employers to extend an employee's probationary period when the circumstances warrant. Once that probationary period has expired, however, if the person is still employed by the governmental agency, he or she now has a vested and protected property interest in his or her job and cannot be terminated at will. Again, this is in contrast with private sector employees who are at-will employees and may be terminated for virtually any reason unless there is some type of contract or collective bargaining agreement that governs the employment relationship and provides the employee with certain contractual rights in his or her job. Many states have laws that prohibit employers from retaliating against an employee who reports any wrongdoing or illegal activity on the part of his or her employer to the appropriate authorities. These laws are known as whistleblower laws, and there are similar provisions in some of the federal laws we discussed in previous modules as well. Such whistleblower laws are designed to protect employees who avail themselves of legal rights or report wrongdoing or illegal conduct related to the workplace against workplace retaliation. Another workplace reality that directly impacts fire departments, EMS agencies, and other emergency service entities is that of proper dress, appearance, and grooming. Stated briefly, employers have the right to define how their employees look and present themselves to their customers and the public they serve. Where things can become interesting is when public employees feel as though their First Amendment freedom of expression is stifled, workplace requirements raise gender equity issues, or some type of accommodation may be necessary given a medical or religious need. Generally speaking, employers are indeed allowed to have grooming requirements, and those requirements may even recognize gender-based differences so long as they are in accordance with commonly accepted social norms and are reasonably related to the employer's business needs. Gender-based requirements that are overly burdensome, are completely unrelated to business necessity, or perpetuate gender stereotypes are typically illegal under Title VII of the Civil Rights Act. For governmental employers, the courts use a rational basis test to determine whether a government agency's grooming and dress code policy is constitutional, considering the employee's right to self-expression. If the government employer can show that a dress code or grooming requirement is rationally related to a legitimate interest, that dress code or grooming requirement will be supported by the courts. Examples of such restrictions include limitations on hair length, as well as prohibitions on beards, tattoos, and body piercings. Fire departments and EMS agencies have the recognized need to maintain their public image and commercial brand. Such dress code and grooming requirements are rationally related to those legitimate interests. We will discuss religious accommodations in just a moment, but such accommodations are occasionally discussed within the context of dress codes and grooming standards. Also related are medical accommodations. To begin, dress code and grooming requirements that are rationally related to a legitimate business interest will be upheld by the courts even if those requirements interfere with the expression of religion or undermine a medical necessity. In some cases, however, an employer may consider it reasonable to provide an exception for an employee based upon one need or another. The important thing for employers is to be consistent and to recognize that, if an exception is made for a medical reason, the exception must be made available for other reasons, such as a religious expression accommodation, and vice versa. The use of self-contained breathing apparatus and having facial hair is a common example in the fire service. If the fire department allows someone to have a beard or facial hair as part of a medical accommodation, it may not refuse to provide the same accommodation to an employee seeking a religious accommodation to also have a beard or facial hair. On the other hand, if a fire department is stoic in its application of industry standards and possibly law on the prohibition of facial hair that interferes with the SCBA face piece seal and does not make any exceptions, such a refusal to make an exception under any circumstances would probably be supported by a court because there is a very legitimate interest on the part of the fire department to not only meet industry standards and laws, but to also ensure a safe working environment for its personnel. As far as religious accommodations are concerned, requests for religious accommodations can encompass much more than just grooming and dress code requirements. Some routine examples include people who cannot work on a specific day of the week in observance of their Sabbath, or the need to pray a certain number of times per day. Simply stated, even government employers do not have to accommodate the religious beliefs of an employee if doing so would cause an undue hardship for the employer given a legitimate business interest. For example, an EMS agency cannot afford to take an ambulance out of service because one of its employees needs to pray. That would constitute an undue hardship. On the other hand, if the employer allows the employee to pray while on duty, so long as the employee interrupts the practice if a call comes in, such an accommodation would probably be deemed very reasonable. Additionally, if the employer makes a similar accommodation for reasons other than religion, if an employee does subsequently request a religious accommodation of a similar nature, the employer must accommodate that request. Such reasonable accommodations could include flexible scheduling, voluntary substitutions, work trades, transfers, reassignments, or some changes to the workplace environment. If an employer decides to either accommodate or not accommodate an employee's request based upon a religious need, consistency is important. If an employer has questions as to whether or not a religious-based request for an accommodation should or can be provided, it is not a bad idea to involve an attorney to assist in making that determination. Another employment issue that has been discussed on constitutional grounds is residency requirements. In many areas of the country, it is not unusual for emergency service agencies to have residency requirements that delineate where their employees may live. The argument for such restrictions on personal autonomy is that protective service agencies need to ensure personnel are available within a reasonable time frame if additional assistance is necessary to mitigate emergencies. There is also a cursory argument that public employees better serve the public when they live in the same community within which they are employed. In many cases, residency requirements are even included within collective bargaining agreements, meaning the restrictions on where a firefighter or police officer can live were part of a bargained-for exchange between the union and the employer. Ultimately, the Supreme Court has upheld residency requirements as being constitutional, even if such requirements are not included within a collective bargaining agreement, given the rational relationship of such requirements to a legitimate government interest. The firefighting and EMS professions can be somewhat unique given not only the job itself, but the 24-hour work schedule often utilized by fire departments and EMS agencies. Those firefighters and EMS providers working 24-hour shifts spend a lot of time at the station. That is where they eat, sleep, and work for almost a third of their time, making the fire or EMS station a home away from home. It is important to remember, however, that despite the comfort and familiarity a firefighter or EMS provider may have in his or her station house, it is still a workplace, and many of the protections and privacies enjoyed within their own homes do not carry over into the station environment. One area of contention is the maintenance of sexually explicit material at the firehouse or EMS station. As denoted in the textbook, there are court cases that both protect the right of a firefighter or EMS provider at work to possess sexually explicit material, as well as recognize the right of others within that workplace to be free from having to view or be exposed to such materials. This can create a somewhat unique quandary for fire service and EMS employers who must maintain a harassment-free environment while also recognizing the rights of personnel to read what they want in privacy within the station house. It seems clear that such materials cannot be openly displayed, and employees with such materials must keep them private without exposing the content to unwitting viewers, as a failure to do so can give rise to a hostile and harassing environment. Privacy in general is also a hot topic for firefighters and EMS providers who spend a lot of time at the station. Given the nature of their schedules, it can be common for firefighters and EMS providers to maintain personal property and private effects at the station in a locker or other storage area. The level of privacy the employee has in that storage space, however, may be the topic of considerable debate, as the employee is not storing those personal items at his or her own residence. These things are being stored at the workplace. To alleviate any confusion, employers are encouraged to have policies and procedures in place that make it clear that the employer has the right at any time to inspect the contents of the employee's storage locker. This is of particular importance for public sector employers, as such a policy helps the employer show that the employee did not have a reasonable expectation of privacy in his or her workplace storage. Other privacy issues may arise with regard to an employee's use of electronic technology as well. The legal considerations related to an employee's use of technology were discussed in a previous module, so we will not cover them again in this particular presentation. Please feel free to revisit the information contained within Chapter 7 of the textbook for a refresher on the topic. Another aspect of the employee-employer relationship that has particular application to fire departments and EMS agencies is eligibility requirements for hire or promotion. Initial hiring may require a certain level of formal education or a particular state license or certification. Promotable opportunities for existing employees may have similar requirements for formal education, licenses, and certifications, along with a certain threshold of seniority or experience. These requirements may even be denoted within a collective bargaining agreement. Many hiring processes and some promotions may even require some combination of written, physical, medical, and psychological testing. In such processes, it is important to ensure compliance with applicable laws, such as Title VII of the Civil Rights Act and the ADA, to avoid potential claims of discriminatory treatment in the hiring or promotional process. Firefighters and EMS providers must be physically fit to perform the strenuous duties of their jobs. Under the ADA, however, a candidate for employment cannot be medically screened until after a job offer is extended. Such a job offer may be made conditional upon the successful completion of a medical examination, so long as all candidates are submitted to the same type of evaluation. Requiring a medical evaluation for employment must be supported by business necessity, and the evaluation must be related to the job being performed. The process by which employment candidates are medically screened is important because an employer does not want to wrongly exclude disabled applicants from employment. If a medical screening process excludes disabled people who can perform the essential job functions either with or without reasonable accommodations, that is a problem. Another interesting caveat related to medical screening of emergency services personnel is that some states have laws that prohibit individuals from being firefighters if they suffer from certain medical conditions, such as heart disease or epilepsy, without the approval of a physician. If you are a fire service employer and such a law exists within your state, it would be important for you to work with a local attorney to ensure that law is accommodated within your medical screening process without running afoul of the ADA. Given the stressful nature of firefighting and EMS work, some fire departments and EMS agencies require a psychological examination as part of a conditional offer of employment. Similar to medical examinations, psychological examinations should not be administered until after an employment offer is made, and that employment offer can then be contingent upon the successful completion of that evaluation. Some employers require job candidates to undergo psychological examinations that are actually behavioral or personality examinations that evaluate behaviors and character traits such as reliability, honesty, and work ethic. Such evaluations are different from a true psychological examination designed to identify mental impairments or disorders and, as a result, are not necessarily considered to be a medical evaluation under the ADA. Where on the spectrum such an evaluation lies, however, can be difficult to determine, and the courts typically err on the side of caution by evaluating facts in the light most favorable to the person with the claimed disability. As a result, caution should be exercised when such evaluations are utilized as a part of the application and hiring process. Another popular employment practice in fire and emergency services is the use of some type of physical ability test before an offer to hire is made. To protect the employer from discrimination lawsuits, such tests must be both job-specific and verifiable. Being job-specific means that the physical ability test assesses the candidate on functions he or she will be performing as part of his or her duties if hired. For example, a candidate physical ability test that requires candidates to run a mile within a certain time frame is not job-specific, as being able to run a certain distance within a given period of time is not an essential function for a firefighter or an EMT. Being able to swing an axe or deadlift a certain amount of weight to simulate lifting a patient, for example, would be job-specific. Verifiability is also important in that the fire department or EMS agency should ensure the hiring requirements are consistent with the performance of their existing workforce. Requiring new employees to perform functions as a part of a physical ability test that existing employees lack the physical ability to perform can give rise to some issues if the test is challenged in court. As a result, candidate physical ability testing parameters should be determined by statistically analyzing actual data of currently employed firefighters or EMS providers performing the same tested functions. If a physical ability test is not job-specific or verifiable, does that automatically mean the test is invalid? Maybe not, as many have argued that general physical conditioning is indicative of overall fitness and the ability to perform strenuous tasks on the fire ground or emergency scene. Generally speaking, however, such tests are routinely challenged and invalidated. To ensure the greatest likelihood that the results of a physical ability test are upheld by a court if challenged, that test should be both job-specific and verifiable. Within this talk about physical ability testing, in addition to conversations about disability accommodations, we have used the term essential job functions several times. Essential job functions are fundamental duties that must be performed by individuals within a specific job or work position, either with or without reasonable accommodations. As far as firefighting and EMS is concerned, there is no one list of essential job functions. Rather, it is up to each hiring agency to perform a position analysis and determine what physical job functions are essential to that position. Those essential job functions can then be used to evaluate the fitness of potential new candidates and existing employees to perform the job. With the ADA in mind, if reasonable accommodations are required to perform an essential job function, then they must be provided. An example may be providing battery-powered amplified stethoscopes for a hearing-impaired EMT. As long as an employee or a potential candidate for the job can perform the essential job functions associated with the position, either with or without a reasonable accommodation, the employee or candidate should be considered fit for duty and cannot be denied employment based upon a disability. Written testing is also a common process for establishing eligibility lists for hire into or promotion within a fire department or EMS agency. Many high-profile legal cases have resulted from such written testing processes, which means employers must be very wary of using such instruments if they have not been previously challenged and upheld in court. The issue commonly stems from written testing instruments that wind up negatively impacting candidates of a particular race, ethnic background, or socioeconomic status. We spoke in a previous module about disparate impact, and if a written examination results in a statistically significant difference between candidates of various classifications or backgrounds, that can be problematic for the employer, even if there was no intent to discriminate within the testing process. Therefore, employers must take affirmative steps to ensure any written testing instrument used for hire or promotion does not result in a disparate impact against individuals within various protected classes. The evaluation of current firefighters and EMS providers for fitness to perform their duties, physically, mentally, and psychologically, can be a difficult subject to broach, as it is important for firefighters and EMS providers to be able to effectively perform their jobs, yet those employed by governmental agencies typically have a protected property interest in their jobs, and even privately employed individuals may also enjoy contractual protections or may have some type of qualifying disability or other status that may make it difficult for an employer to address issues related to physical preparedness, psychological health, and mental acuity. If a firefighter or EMS provider is no longer able to perform the job due to a physical, mental, or psychological impairment, the employer must act out of the best interests of the public being served while also accommodating the rights of that employee. Along similar lines, some jurisdictions recognize the impact of age on the body and mandate a specific retirement age for individuals employed within emergency service disciplines. Beyond clear-cut cases, which can include statutory age limitations, it can be more difficult for public employers to define and enforce specific health and fitness requirements for employees. Performance is important for emergency service workers, and there are many examples in the private sector where a decrease in work performance, even if the decrease is a result of physical fitness, can mean the end of a job or career. Professional sports are an excellent example of that. Lose a physical advantage, and continued employment may be tenuous at best. Applying some type of similar performance standard to firefighters and EMS providers can be more difficult, however. Given the rate of injuries, cancer, suicides, psychological issues, and so on within the firefighting and EMS professions, many are arguing that something should be done to foster physical and psychological health while also ensuring adequate and appropriate mental acuity to learn, retain information, and think critically under stressful circumstances. When developing programs to foster employee health and safety, it is important for employers to consult with legal counsel if poor employee performance in such a program could potentially lead to some type of negative employment action against the employee. Many advocate for collaborative, non-punitive programs to support such initiatives. Regardless of the intentions of the employer, if an employee's property interest is threatened or a potential disability is involved in the implementation or maintenance of such a program, legal complications for the employer are almost certain. Drug testing is another hot topic that relates directly to an employee's fitness for duty. There is a clear and legitimate expectation on behalf of emergency service employers and the public they serve that firefighters and EMS providers are not impaired by alcohol or drugs while at work. On the other hand, employees do not check their constitutional protections at the proverbial door when they come to work, and the Supreme Court has recognized that drug testing by a government employer constitutes a search and seizure under the Fourth Amendment, as applied against the states by the 14th Amendment. Therefore, whether drug testing of a firefighter or EMS provider by his or her employer is constitutional depends on the reasonableness of that testing. Drug testing for cause, as well as random drug testing programs, even without probable suspicion, have been deemed reasonable and, therefore, constitutional by the courts. While private employers do not have to worry about constitutional concerns surrounding drug testing for the most part, there are still some broadly shared concerns about drug testing that impact both public and private employment entities. Some states may also limit the scope and permissibility of drug testing employees, which may also cover private employers. Some states do not permit random drug testing and, instead, require that there be a showing of reasonable suspicion before an employee can be tested. Other states allow random drug testing of only people employed in positions of importance to the public, which would include firefighters and EMS providers. As with all of the subjects we have been discussing, it is important for those involved in the employment relationship to be familiar with the laws that apply within their specific state. In a previous module, we discussed the Federal Genetic Information Non-Discrimination Act of 2008, which makes it illegal to discriminate in the workplace on the basis of an employee's genetic information. This law obviously has an impact on the employment relationship, and many states have similar legislation on the books as well. The use of polygraphs, or lie detectors as they are commonly known, voice stress analyzers, or other similar technology used to be a somewhat common practice with some employers during job interviews and wrongdoing investigations to verify candidate or employee honesty in his or her responses. The problem, however, is that these devices are not always accurate, and many have argued that their use violates the Fifth Amendment right to avoid self-incrimination. In 1988, Congress passed the Employee Polygraph Protection Act, which made it illegal for a private employer to use lie detector tests for pre-employment screening or during the course of that individual's employment. The employer also cannot discharge, discipline, or discriminate against an employee who refuses to take a lie detector test and exercises the rights guaranteed by the law. There are exceptions to the law that include criminal investigations and cases where there are significant security concerns associated with a particular employee's position or duties. Additionally, as you may have noted already, this law only applies to private employers. It does not address governmental employers. In this regard, it is important to be familiar with the laws in your state, as some states have similar prohibitions against polygraph tests within the public sector employment relationship. With these various testing considerations and laws in mind, what happens if discrimination is deemed to have occurred within a hiring or promotional process? In such cases, it is not uncommon for the employer to enter into a consent decree with the governing court to address future disparities in the hiring or promotional process. Consent decrees are agreements between the court and the employer to conduct the hiring or promotional process in a particular fashion. One common provision designed to combat disparate impact discrimination based upon race or socioeconomic background is that the employer must strive to have an employment workforce that proportionately reflects the diversity of the population it serves. Thus, if a fire department has a workforce comprised of 95% Caucasian males, yet the area it serves is 60% African American, that is a disparity that must commonly be addressed through aggressive recruitment efforts as denoted within a consent decree, assuming there was a discrimination lawsuit that arose as a result of that disparity. With this in mind, employers must also be cautious to not overcompensate to avoid discrimination against a minority group in the hiring or promotional processes to the detriment of a non-minority or non-protected class of employees. If such does indeed occur, a reverse discrimination complaint may be filed by the impacted non-minority candidates or employees. To address the concern and work toward an equitable hiring or promotional process for all candidates or employees, protective service employers should develop mentorship, professional development, and continuing education programs for their personnel. Additionally, when recruiting applicants for entry-level positions, the employer should be certain to focus efforts on underrepresented groups within its current workforce while also ensuring a transparent and open process for everyone. While it has been mentioned numerous times before, it bears repeating here. Involving an attorney during the development of such a hiring or promotional process can be very beneficial for ensuring compliance with both state and federal laws, while also avoiding potential pitfalls in the process that could lead to a discrimination claim. With that, we are now at the end of the module. To summarize, you learned about the doctrine of respondent superior and how an employer is typically responsible for the negligent or otherwise bad actions of its employees. Performance evaluation systems, when used fairly and correctly, are valuable tools in both maintaining and increasing worker satisfaction and productivity. If ever called upon to provide an employment reference for a current or former employee, it is best to ensure such a reference is provided in good faith and that the reference includes only facts without providing personal feelings or interpretations. Be objective, not subjective, in providing the reference. We explored organized labor and started the discussion with information about the 1935 National Labor Relations Act, which was designed to protect the rights of employees and employers, to encourage collective bargaining, and to curtail certain private sector labor and management practices which can harm the general welfare of workers, businesses, and the United States economy. Within that organized labor discussion, we looked at unions and explored their responsibility to bargain collectively with the employer on behalf of their respective membership. We also identified several unfair labor practices that are considered to be illegal under the National Labor Relations Act. Grooming and dress code requirements within the workplace were discussed, along with religious accommodation requirements for employees. Lastly, the module looked at the legalities involved with various types of testing that may be performed by an employer to qualify candidates for jobs or promotions and how to avoid legal pitfalls associated with those different process components. Our next chapter will conclude our course of study on common laws that impact fire and emergency medical services by exploring laws related to the responsibilities every firefighter, EMS provider, fire department, and EMS agency has to the public they serve.